our Secure Act webinar today. For those of you not familiar, the Secure Act is a law that Congress passed back in right at the end of 2019. So last year, 2020, was the first full year of it being in effect. But it essentially changed quite a bit about how qualified retirement accounts function, and somewhat during your lifetime, but really particularly for the beneficiaries of those accounts after you pass. And they're pretty significant changes, pretty much the most significant changes in the last 30 or so years, certainly how those accounts function. And it can really go into what the tax impact is on these beneficiaries. So you want to do planning in advance if you're able to help sort of diffuse that tax bomb over time, or at least make amendments to your plan to deal with it. So welcome everybody. For those of you who don't know me, I am Attorney Justin Randall here with Hooper Law Office. Our topic today is the very, for those of you who are not interested in tax, not necessarily interesting, but still incredibly important topic. I find this topic very interesting. So the Secure Act is our topic today, and the Secure Act was a law passed by Congress back in right at the end of 2019, and it came into effect in 2020 right away. So after January 1st of 2020, this rule began to impact anybody who owns a retirement account, and by that I mean like an IRA, 401k, Roth, those types of accounts. It impacted a couple different things. Some of those things were impacted are impacted during the life of the original owner of that account. But the really major changes that impact the most significant changes anyway, that also have the most significant consequences, are how those accounts are now treated for beneficiaries. So after the original owner passes. So those are some of the things we're going to be going through today. If anybody is participating via Zoom, you can ask questions as I go along. There's a Q&A function. And if you pre-registered through Zoom as well, you will be receiving our little chart of pre-Secure Act, post-Secure Act changes to some of those rules. And I'll go through all of them today too, but it's a handy little cheat sheet if you're ever curious about kind of what changed. How a lot of estate plans dealt with these types of accounts in the past. So, they basically allowed for required minimum distributions to be taken out by the kids. A lot of our plans pre-Secure Act would have things related to, forcing out required minimums to the beneficiaries in order to have see-through status to the beneficiary and see their age, all things like that. But I'll start with how it impacts those of you who have retirement accounts right now and what that changes for you. So prior to the change, pre-Secure Act, once you hit age 70 and a half, you had to start taking out what they called required minimum distributions from those accounts. Essentially, it was an amount that was calculated based off of your current life expectancy. So it was the minimum you had to take out every year. It was taxable if it was not a Roth. Roths, you did not have to take required minimums out of if you are the original owner of that account. So 70 and a half was the age. And then when you passed, you had to, as the beneficiary of those accounts, especially if you're an individual, like a son or a daughter, family member, things like that, you had to begin taking those required minimums at whatever age you were right away. So you did not have I get to wait until 70 and a half. It was, if a 25-year-old inherited an IRA from a parent, they had to start taking required minimum distributions right away. And that was based off of their life expectancy as well. Although the difference there was if you were the original owner of the account, they recalculated that life expectancy every year. Whereas at the beneficiary of that account, it was the one time. So eventually, you might run out of those minimum distributions being given out. It might completely liquidate the account at some point. So the benefit of that lifetime payout, though, was although they had to start taking it right away, that lifetime stretch for tax purposes was really nice because the taxes had to be paid on it at least, but they could still stretch it out over, possibly decades. And Roth IRAs, the nice thing was, yeah, you didn't have to pay tax on it. The tax was already paid, but you still had to take the distributions out, unlike the original owner of that account. So there was a lot of good tax planning that could be done because people were able to do that stretch and able to just minimize that tax hit. So even potentially a couple $100,000 of an IRA account going to a single beneficiary would, be able to stretch it out over time. I mean, there was still planning you wanted to do with, what is the beneficiaries, um, likely income. It might make more sense if you're trying to equalize an estate for maybe the doctor in your family to get cold hard cash, and the somebody who is maybe a student, right, and not currently generating a lot of income getting an IRA, because you would maximize the benefit there. So there was a lot of planning you could do still, but they did have to begin taking those required minimums right away. So a lot of our plans allowed for that and were specifically structured to allow the best tax planning possible for things like that. Well, under the new rules, a couple of different things have changed. So I mentioned there's kind of the during your lifetime changes and then the for your beneficiary changes. And and one thing I forgot to mention under the old rules is you could not contribute to an IRA or 401k or those types of accounts once you hit age 70 and a half. You had to, at that point, you were done contributing. They wouldn't let you do it anymore. But under the new Secure Act changes, if you had not reached age 70 and a half prior to this law change, so you were not already taking required minimum distributions, when the law changed, they upped the age at which you had to start taking those required minimum distributions to age 72. So if you were 68 when this law changed, you now don't have to take the required minimums out until you are age 72. If you had already hit age 70 and a half, you don't get to stop taking your required minimum distributions. You still have to continue on from that point. This year, obviously, or I should say 2020 was an exception. We'll see about 2021 what happens here. But with 2020, you did not have to take required minimums if you had already started, just because of the CARES Act regarding COVID relief and all of that. So that was why nobody had to take any required minimums last year. It is not related to the Secure Act in that sense. One of the benefits of the Secure Act as well is kind of structured because a lot of people are working longer now. So if somebody is working beyond age 70 and a half, you can actually continue to contribute as long as you're working. You may still have to take required minimums out at age 72, but you can still, for example, the founder of our firm is 76, I believe, and he's still working. So in theory, if he wanted to contribute, he still could, right? So no maximum age anymore that you can contribute, unlike under the pre-Secure Act rules, but you do still have to start taking required minimum distributions out at age 72. Like I mentioned, there's a lot more changes though with how beneficiaries are dealt with under the new rules. So Congress, as a way to essentially raise more tax revenue, shortened the length of time that a beneficiary has to take out these distributions. They no longer, as beneficiaries, have to take them out as required minimums, meaning every year they are not obligated to take a certain amount out like they were under the old rules. But they now only have a maximum of 10 years to take the entire account out. And if they do not take it out by the end of year 10, it is liquidated all at once, which, if it is pre-tax money, is obviously a potential tax nightmare waiting to happen, because now, rather than stretching it out over at least the 10 years, you have all of it at once. And depending on the size of the account, that could be obviously a huge disaster, or maybe not that much of a disaster if it's a much smaller account. It just really depends. But you still want to be a lot more intentional now about how you are, as a beneficiary, engaging in this tax planning around these accounts. I should mention as well is that if you did inherit an IRA pre-Secure Act, so if you had a parent that passed away in like 2018, for example, and you were inheriting an IRA or inherited it from any source, you still get the required minimum distributions out. They did not change that rule or make it retroactive in that sense. So you do have that ability to stretch it out still if you inherited it pre Secure Act towards the end of 2019. So that, not to scare anybody there, if you have an IRA that you inherited and thought, oh my gosh, I'm going to have to suddenly take this all out in 10 years. But January 1st of 2020, that point on, if you inherited an IRA at that point, you do have to take the entire thing out by 10 years. And that is still true with a Roth IRA as well. You still have the 10 years. There are some exceptions to that 10-year payout, though. So if you are the surviving spouse of somebody who has passed and you inherited their IRA, you still can do a spousal rollover. You can still use your own life expectancy there and treat it as if it were your own IRA. That rule still exists. So spouses are not suddenly required to take the entire account out by the end of year 10. They can still stretch it out over time. There are some other minor exceptions too that generally don't apply to a lot of people. They're very specific. So one that may apply to more people is if the beneficiary that's inheriting that IRA or 401k, if they are a minor, they get a lifetime stretch until they're age 18. And then once they're 18, they have 10 years at that point. So it's still not a full lifetime stretch. It's, so if somebody inherited at age 8 an IRA, for example, they would technically have 20 years at that point to take it out, and they'd have to take the whole thing out by age 28. So it really just kind of depends on how old they are when they inherit, if they are a minor, what their actual stretch is at that point. If they are an adult, there are still some exceptions. So if it's a disabled child of the beneficiary, that is something that they can receive that stretch, lifetime stretch for too. So they don't have to take it all out in 10 years if they are, a child with special needs, but are an adult child. They don't have to take it out if they have any other form of disability in which they are disabled under not necessarily the statute you would think, but under the meaning of, how the IRS defines disability, which is a very vague definition, quite frankly. It's essentially if they cannot engage in meaningful, gainful activity, which, essentially means they're not employed, but also that gainful activity definition, the lines can be a little blurred depending on what they deem gainful activity, if, they're bringing income in from any source, right? So it's just something to be aware of, but, that's there so that you're not in any way harming like benefits for these disabled children, or harming them substantially by a much quicker payout, or, forcing them to deal with significant tax consequences. Chronically ill individuals also meet that definition. So, if you're a chronically ill child of a beneficiary, you don't have to take the entire thing out by year 10. And chronically ill is again defined under the IRS code, not under, like the Medicaid rules or anything like that. It's under how the IRS would deem someone chronically ill. And then the really strange exception that they put in, and one that we're kind of waiting to see exactly how they end up holding people to this, is if the beneficiary is not more than 10 years younger than the original account owner. So that can mean possibly one of two things, right? It obviously means not more than 10 years younger. So if you are 5 years younger, like somebody's brother or sister that they're leaving an IRA to, potentially, well, you're not more than 10 years younger, so you get a stretch as well, right? But does that also mean anybody who is older than the original beneficiary, did they still get a lifetime stretch? And that's how I would read it, certainly. But who knows how the IRS is going to end up holding this over time. And we may have to hear back from, like opinions that are written by the IRS, and, what happens in court potentially, which hopefully, they give the benefit of the doubt and they give the best result possible. So even older beneficiaries can get that stretch. But it's such a new law, we're going to have to wait and see. So there are, there are some things as well that if you are the account owner, it used to be that under pre-Secure Act rules, prior to age 59 and a half, you had a penalty if you withdrew early. So if you withdrew before age 59 and a half, even if you were 60 and had not started your RMDs, you could still withdraw without a penalty. You still had to pay tax on it, but no additional penalty. Under the Secure Act, or excuse me, pre-Secure Act rules, if you were 59 and not yet 59 and a half, or 40 and not yet 59 and a half, you could be penalized or would be penalized for withdrawing early. Under the new rules, there are certain exceptions to that early withdrawal. They're qualified early withdrawals. So for example, for the birth or adoption of a child, you can actually withdraw $5,000 penalty-free per child. And then also for student loan payments, they allow you to withdraw a maximum lifetime amount of $10,000 for student loan payments penalty-free. Bear in mind that this does not make them tax-free necessarily, but they are penalty-free. So there are some qualified exceptions. So the question becomes, though, okay, how do I deal with these changes? What can I still do to do tax planning for my kids, or for myself for that matter, or for other beneficiaries that I want to leave these accounts to? How do I make sure that I'm not expediting the taxes on these things for that would have been a lifetime stretch before, but are now this relatively short 5-year payout? And there's a lot you can do during your lifetime to stretch the tax out yourself, right? So those of you familiar with Roth IRAs, Roth, 401k, Roth accounts, things like that, you will know that, okay, you've paid the tax going in to those accounts. So, if you set up a Roth while you're still working, under a certain amount of annual income, they are limited on an upper end. Under a certain amount, you can contribute, you pay the tax up front, but with a Roth, that account grows tax-free, and you actually, during your lifetime, are not obligated to take out RMDs from a Roth if you are the original owner of that account, that is. Something a lot of people are unfamiliar with or are a little skeptical of is what's called a Roth conversion. That's where you take money from your traditional 401k, traditional IRA, 403b, those types of accounts, and you convert them to a Roth. That involves you paying the taxes on it. That involves, making sure that the government is paid what they want to see from it, which is any tax money owed. But you have the ability to do that over time. I mean, you certainly wouldn't do a Roth conversion all at once necessarily, where somebody's dumping the entire, 100,000, 200,000, however much pre-tax account into a post-tax account, because what was the benefit of that? You would have been better off letting your kids have 10 years. So the strategy involves looking at what your income is every year, working with a CPA who is familiar with the strategy, and working with your financial planner who's familiar with this strategy to slowly move assets from the pre-tax account to the post-tax account. And you can do that over many, many years. You still want to generally wait until retirement to start looking at that, just because for the most part, your income tax brackets are much higher while you're working, or you're in a much higher bracket while you're working than you are when you're retired. So you can potentially pay lower taxes on your Roth conversion if you're doing it when you're retired at a lower income rate. Another factor to think about when you're looking at this is, are your kids at a higher tax bracket, or likely to be at a higher tax bracket than you are currently as well? So a good example of this I sort of mentioned earlier is somebody who has like a surgeon as a child. Well, they're very likely to be in a pretty high tax bracket, if not the highest tax bracket. So if you are at the 22% tax bracket and not the 37% tax bracket, well, maybe there's some benefit in doing that Roth conversion, even if potentially you're still working past, or into your 70s, right? It might still be beneficial to look at doing that because they are likely to pay a much larger amount of tax anyway, even under the old rules. But under the current rules, they're paying a much higher rate than you at a much faster pace to and at much higher amounts every year potentially. So it just means even more is going to those going to taxes and not to the benefit of your beneficiary, right? So this is certainly not something an attorney will know that this is good planning. A estate planning attorney will know that this is good planning, but it's an essential thing to work with an accountant on this and a financial planner, because they're the ones who are able to say, well, you're at this tax bracket this year, or you're going to be at a much lower one next year, so maybe do more next year versus this year. You definitely want to work with kind of a team of professionals when you're doing this. It's good to have kind of all of those perspectives and on this, on how much to convert every year. So that's the number one thing that you can do to really sort of diffuse that bomb in advance, that tax bomb in advance, rather than leave it to the 10-year payout of your children. One thing to absolutely keep in mind, and there were problems with this under the previous rules as well, is to make sure that you are leaving these assets or these accounts to unless it's a charity or something like that, based on the terms of your estate planning, you can accidentally cause a 5-year payout, which is obviously shorter than the 10-year and causes even worse tax situations. So the 5-year payout can happen for a number of reasons, but the essential rule is that if it is not given to what they call a designated beneficiary, which essentially an easy way to think about it is, are they an individual, right? So your kids, family members, friends are individuals. Charities, different, like academic institutions, all those things are not designated beneficiaries. So they would be forced to do a 5-year payout if they inherited it. So that's usually not an issue if you're leaving it all to charity, because they don't pay income tax. So it's not as big of a deal for that. But where the issue really comes up is, depending on your estate planning, if you are leaving your assets to your children and they are inheriting in a trust, and by that I mean whether or not you yourself have a trust, they themselves are inheriting a trust from you. Depending on the terms of those trusts, if it's possible that it can go to a charity at some point, especially if it is not seeing through directly to that beneficiary, the individual beneficiary, and maybe it says something like, well, after they pass, it automatically goes to charity, or if it's a certain type of trust where it says, well, they can leave it to whomever they want, but if they don't, it's going to charity. And there are different types of trusts that can come into play with, but that can ultimately force a 5-year payout for the individual as well. So you want to be very careful in terms of your estate plan, what you're doing is with that type of account, and what the terms of your estate plan say and how it's set up can really either cause a massive tax problem at the time of your passing, or it can be still very beneficial for the beneficiary. It's just, or as beneficial as it can be under the new rule. One of the biggest mistakes I've seen, I certainly did not do this plan. It was a client of mine that came in and said this happened with their family's estate, is when you leave a qualified retirement account to the estate. So, things like 401ks, IRAs, you absolutely don't want to go to probate, because it can and very likely will create a 5-year payout, which in this instance happened with almost $1 million IRA. So you can imagine how upset they were that this had to happen. And I will stress again, I did not do this planning because I would not ever want to send an IRA or 401k or any account like that to probate. And just to remind you guys again, this is obviously very tax heavy topic and very you're certainly not expected to get all of this all at once. So if you have any questions, you can submit them to that Q&A box. If you have current planning and you have any questions about how that's maybe impacted by this law change, please feel free to ask. So what when it comes to how people are inheriting these accounts and what the original account owner's estate plan is, under the old rules, the way we would want this, if you were leaving a trust to a child, for example, the way we would want this trust to be set up is what in legalese is called a conduit trust. That means it had to pay out the income directly to the beneficiary, and it had to pay out those RMDs every year. And that's what you wanted, because it allowed each beneficiary to use their own life expectancy when you calculated that at the time of death and when they were inheriting. So that's what you wanted under the old rules. Under the current rules with conduit provisions, that essentially means if you had those same provisions and you didn't update a trust plan, that would essentially mean the entire account is paid out to the beneficiary at year 10. And the reason that can be a problem is there may be asset protection planning that you did for your child through your estate plan. And especially if they have a trust themselves or are getting a trust from you, you want as much as possible to stay in that trust, because once it's out of that trust, it's no longer receiving that asset protection. So, under the old rules, they might have asset protection over an IRA if you had it planned that way for decades, right? Now it's, well, by the end of year 10, if you have those provisions, it's no longer protected. So, absolutely talk, if you have an estate planning attorney, talk to them about that issue, because it is something that you want to deal with. I mean, you want to, plan around that potential. If your goal in particular is asset protection, you want to plan around that change. So how we deal with that now, for example, is rather than what's called a conduit trust, we use what's known as an accumulation trust. So an accumulation trust essentially means that the beneficiary now has an option to take out the any income generated or leave it in the trust itself. There's tax considerations that would come into that, asset or protection considerations that come into that decision, and they can make it year by year, but it gives them the choice. So generally speaking, trusts themselves as a beneficiary with a trust, they get taxed at a higher rate, or generally speaking, than an individual would. They have the same tax brackets, but they get taxed at a very compressed rate. So think of it as if a trust gets roughly 12 grand a year in income, and it is the beneficiary's trust, that means it's getting taxed at the 37% bracket at 12 grand. So it's really not that much. So the beneficiary may need to make the decision of, okay, maybe I'm getting sued this year, or I'm filing for bankruptcy, or something like that's happening. So yeah, I would pay a lower tax rate if I took it out for myself, but it also makes it available to those liabilities. So if that's happening that year, so that beneficiary may opt to say, well, I'm going to pay the higher tax, but keep it safe. What I do remains after taxes, I'll keep it safe. And any other year, beneficiary without those liabilities may say, well, I don't need the protection, I'll take it out and pay at a much lower rate. This actually highlights, though, the absolute benefit of doing these Roth conversions that I mentioned earlier, because you can essentially make it so that the kids don't have to pay taxes at all by inheriting a Roth rather than a traditional retirement account like a 401k or IRA that is not a Roth. That they still have to take it out in the 10 years, but they don't have that same problem of, oh my gosh, look at all these taxes I'm going to have to pay, or I'm in such a high bracket already, and this is just going to be mostly eaten up by these taxes, or at least a significant chunk. So one of the huge benefits of these Roth IRAs, I mean, now a Roth IRA is potentially, and even previously was, one of the best things you could inherit, because it grows tax-free. Even for a beneficiary, if there's any growth after they inherit, it is tax-free. But they still have to take it out, unlike you. But under the new rules, that 10-year payout, like I mentioned earlier, is not every year they have to take out a certain amount. It is beneficial to do that with a pre-tax account, obviously, to do some tax planning, but with a Roth, if it's growing tax-free for 10 years, that might be very beneficial to wait until the end of year 10. So if you take anything away from this webinar today, know that, tax stuff is always very complicated, right? There's a reason that CPAs go to school for as long as they do and have to take as many tests as they do to actually become a CPA. I don't remember the exact amount. I have a couple friends who are, and I believe it's at least 5 tests. At least the bar is only 1. Yeah, so I mean, this is complicated stuff. So if you have any questions, please feel free to email learnmore@hooperlawoffice.com or give us a call and set up an appointment. To remind everybody, we don't have any, our initial consultations are free of charge. They're complimentary. So if you would like us to reach out to you to set something up, if you're participating via Zoom and you pre-registered, you'll be receiving an evaluation form, which is a mixture of, tell us how we did, if there's any topics you'd like to hear, things like that. But also there's a place for you to fill out and say that you'd like us to reach out to you to set up a consultation. And again, that initial consultation is free of charge. It's really important if you have any questions or concerns that your questions are answered and that we really get to know the situation before we can assess what we would recommend as a solution. So that's why we don't charge for those initial consultations. And they're usually scheduled for about 2 hours. So give or take, I mean, it depends. It might be a shorter meeting if it's relatively straightforward conversation, or if there's a lot more complexity, it can obviously take a little longer. But our topic next week, for those of you who are interested, is we're going to be doing a topic on farm planning. So our legendary, and that is a pun, yes, estate planning topic. But then the week after that, we're going to be talking a little bit about, what is a personal representative, or what many people would be familiar with is in other states calling it an executor. What does that personal representative really need to be aware of if they have a family member going through probate, a family member's estate rather going through probate? What are their obligations? What kind of steps are involved? So that will be not next week, but the week after that. So thank you all for joining this afternoon, and I'll look forward to hearing from you guys if you have any questions, and I'll hopefully